Good day and welcome to another exciting episode of the Law Lab. Today we are looking at the law of tort, specifically assault. Assault is an incomplete battery, and it is the only tort that gives a relief for an emotional disturbance. When I say assault is an incomplete battery, recall that in our previous episode, we treated battery and we said that for the tort of battery to lie, 6 elements must be present, i.e., 1, there should be the direct act or the act complained of should be the direct act of the defendant. 2, the act complained of should be the voluntary act of the defendant. We looked at the element of state of mind. We moved ahead to look at physical contact, lack of consent, and we ended by looking at that it is a positive act and not omission to act. Remember our popular maxim in tort law that not doing is no trespass. Not doing is no trespass. Clearly, when I mentioned that assault is an incomplete battery, all that I am trying to tell you is that assault has all the elements of battery with the exception of a physical contact. So any time or any point in time that anyone puts you in a fear or an immediate apprehension of an imminent battery, then it means that assault will lie. If the person is putting you in an immediate apprehension of battery, meaning there was no physical contact, that circumstance or in that situation, assault will lie. And when we talk of assault, we will be looking at 2 critical elements or constituent elements for us to say that indeed assault has lied. Now, the first element we will be considering is that we'll be looking at an act manifesting an intention or threat of committing or threat to commit a battery. An act manifesting an intention or threat to commit battery. And the second element is the capacity or ability of the defendant to carry out the threat. So the first element, and I am taking it again, an act manifesting an intention or threat to commit battery. And the second one is the capacity or ability of the defendant to carry out that intention or threat that I've already stated in element A. If the person does not have the capacity or ability to carry out the said threats, as I have early on stated, then clearly assault will not lie. Assault would only lie when these 2 elements are present. And if you carefully listen to me, you could clearly reflect on our lesson in battery and get to know that the 5 elements of battery has been duly captured in element 1, and element 2 is only talking about the capacity of that person to execute or carry out the said element in the said act or the said act manifesting the intention or threat to commit battery. Now, we have our 2 elements. Let us consider some 3 cases to see whether these 2 elements were present in and whether or not the court will say assault will lie. Our first case we will be considering is Stephen versus Myers. I call it the parish priest case because this was the case. Actually, the fact of the case is that there was a meeting being held in a parish hall where the chairman is the plaintiff and the defendant happened to be sitting about on the seat person to the chairman's place. And the defendant is believed to have been misbehaving in the meeting, and the chairman asks that he has to be taken or sacked or moved outside the hall. The defendant got angry and now came out with a fist, moving towards the chairman that he would rather drag the chairman out of the parish hall. Thankfully or fortunately for the chairman, there were some people who blocked the defendant from getting to the chairman. Now, the chairman brought an action for assault. The defense of the defendant is that I did not get closer or close to the chairman. The court is saying that 1, there was an act manifesting an intention to or a threat to commit battery. And 2, you had that capacity to carry out that battery, but for the prevention of the people. So it doesn't matter whether you got closer to the chairman or not. Meaning, but for the people preventing the defendant, he would have moved with his fist to hit the chairman. And so in that particular instance, the court said assault would lie. Now, another case I want us to consider in determining the meaning or the constituent element of assault is Reed versus Coker. Reed versus Coker. In Reed versus Coker, the plaintiff or the claimant went to the defendant's shop, and the defendant and some of his workmen gathered around him and told him to move out of the shop area, else they are going to break his neck. Now, the point is, the court examined the fact of the case and stated that there was an act manifesting an intention or threat to commit battery. And also, the defendant, together with his servants and agents, had that capacity to carry out the said threat or intention they were actually exhibiting. And so the court stated that in that particular instance, assault would lie. The next case I want us to consider is the case of Thomas versus National Union of Mine Workers. Thomas versus National Union of Mine Workers. Remember, you can use "and" for the V. Just for clarity, that is why I mentioned versus, because it's in most civil matters, we use "and" not the versus. But the versus mostly is used in criminal matters. But for the purpose of our education and clarity in our teaching, for us to know a clear distinction between the plaintiff or the claimant and the defendant, I'll be using versus as we move ahead. Now, in Thomas versus National Union of Mine Workers, I know most of you watching have witnessed how strikes do happen in this country. Let's say the Workers' Union of, let's say TUC, the Trade Union Congress, have declared strike for all workers in Ghana. The executives of the Trade Union Congress take it upon themselves to be going around to note workers who disobey their order and try to pull them out for them to enforce the strike. It is in similar or such similar circumstance happened in the case of Thomas versus National Union of Mine Workers, where the National Union of Mine Workers had declared strike. It took Thomas and some few other staff who stated that we don't care about your strike, we are going to work. And so the company provided them with a van and a police officer guarding them. So the van moves to their houses, picks them with a police officer in it, then drives them to work and also back from work. The National Union of Mine Workers would gather on the streets, on both ends of the streets, while Thomas and others are being driven to or chauffeured to work. They will be shouting, insulting, and threatening violence. And so Thomas brought an action against the National Union of Mine Workers. The court is saying that, yes, indeed, element 1 will lie, because there was an act manifesting an intention or a threat to commit battery. However, element 2 would not lie, which would negate the assault or would not make the action of assault successful, in the sense that the National Union of Mine Workers did not have the capacity or ability to carry out the threat they were casting out or gushing out. In the sense that you, Thomas, you were in a moving vehicle. They did not touch the vehicle. Also, you had a police or a security officer in the car to protect you. And so element 2 would not lie, because the National Union of Mine Workers do not have the capacity to carry out the intention or the threat of violence to commit a battery that they were gushing or casting out. Now, knowing the definition or the constituent element of assault, the next thing I believe we need to consider is our challenges or the challenges we encounter when somebody pulls a revolver at you. Would assault lie? Because there is that clear case of when somebody pulls a revolver at you and points it at you, that person puts you to an imminent fear or imminent apprehension of the person committing battery on you. And in such circumstance, let's say the person or the revolver is not loaded or the gun is not loaded, would assault lie? The court is saying in the case of Blake versus Barnard, I just want to make it clear that the challenges or the history towards gun cases or pointing a revolver at someone has graduated to a certain level, and as such, I will start from the previous position of the law in Blake and Barnard and end at R versus St. George, which clearly gives a clear indication of the position of the law on gun cases or pointing a revolver at someone. Now, in the clear case of Blake versus Barnard, where the gentleman points an unloaded revolver at the defendant, the plaintiff, the court is saying that for that, assault will not lie because the revolver was not loaded. Now, the position of law has changed in the case of Osborne versus Veach. In the case of Osborne versus Veach, in the case of Osborne versus Veach, the principle that the courts actually established was that a half-loaded gun is as good as a half-cocked gun is as good as a fully loaded gun. A half-cocked gun is as good as a fully loaded gun. So in that particular instance, assault would lie. Now let's move on to the current position of the law. The current position of the law as stated or established or espoused in the case of R versus St. George. In R versus St. George, the court stated that when somebody points a revolver at you, whether loaded or unloaded, assault will lie, unless, or with the exception that the one of which the revolver is pointed at had the knowledge that the revolver is not loaded. So if you have the knowledge that the revolver is not loaded, assault will not lie. But if you have no knowledge of whether or not the revolver is loaded, and the person points the revolver at you, whether the revolver is loaded or not, assault will lie. However, when the defendant is able to establish that you had knowledge that the revolver was not loaded, then assault will not lie. Now, we are talking about putting someone in an immediate apprehension of battery, or you are putting the person on fear, or you are putting certain fear on the person that you are going to commit battery. I want to ask a very simple question, which I will lead all of us here watching to answer such question. The simple question is, can mere words constitute assault? Can mere words constitute assault? Please, don't forget that anytime you are answering any assault question, make sure that the two elements I've early on mentioned, i.e. an act manifesting an intention or threat to commit battery, or looking at the capacity or ability of the person to carry out that intention. Make sure that you examine these two elements in whichever case the assault question is presented. So moving on to our topic, can mere words constitute an assault? Clearly, we would look at the person giving the mere words, which probably threatens, or the person threatens through these mere words to commit battery. We would also consider that person's capacity or ability to carry out the said intention. And so our first case is R versus beaded belt, where the gentleman or the victim of that particular circumstance moved to the defendant's house, was singing war songs, shouting, insulting that person, threatening that person to commit violence or battery, and the defendant moving out of his house went straight to shoot the person or shot at the victim. Now, when the defendant was arraigned before the court, his argument was that the person committed assault on him. The court is saying that assault would not lie, because though the person was threatening violence or threatening to commit battery, he was behind your house and did not have the capacity or ability to carry out that threat or intention. We may consider the case of R versus Wilson. I call it the gamekeeper's case. In R and Wilson, what happened was very simple. Where the gentleman was playing the game and he was being chased out of the game hall, and he heard the defendant shouting, "Get me the knife, get me the knife." The court is saying that in that particular instance, assault will lie in the sense that those mere words of "get me the knife" meant that the person also would have capacity to carry out that intention of committing a battery. The next case I would want us to consider is the case of R versus Constanza. In the case of R versus Constanza, well, this goes for the boys. When you are pursuing a lady, take your time. You might end up committing assault. In the sense that the gentleman pursuing a lady decided that he will be writing letters to the lady and wrote over 800 letters to the lady. Unfortunately for her, or for him, the lady, after reading one of the letters, suffered from a psychological problem. Now, the court is saying that such mere words would constitute assault because the gentleman had the capacity of carrying out such words he wrote to the lady. The last subheading I want us to be treating in this particular episode or under assault is, would conditional statement also constitute assault? Would conditional statement also constitute assault? In this particular circumstance, the court is saying that conditional statement would not constitute assault because the conditional statement would negate the defendant's ability or capacity to carry out the said intention. Now, let's look at the case of Tuberville versus Salvage. Tuberville versus Salvage. Now, in Tuberville versus Salvage, the gentleman touched his sword and now stated that if not a Caesar time, you would have seen what I would have done to you. The court is saying that the if preceding or prefixing the conditional statement negates the capacity or the intention the person has to commit the battery. The last subheading I would want us to treat is assessment of damage in assault and battery. Remember, both assault and battery are actionable per se. If I say actionable per se, it means that you need not to prove any actual injury before such thought would lie. However, when there is an actual injury, it means that it will increase the quantum of damages the person will claim. But assault and battery are actionable per se, meaning you need not to prove any actual injury. Today, we looked at the tort of assault, and as a matter of recap, to know all that we've done, we started by stating that assault is the only tort that gives relief for emotional disturbance. And as such, it is an incomplete battery, where we stated that it has all the elements of battery. However, it is minus physical contact. And so, for assault to lie, we stated that there must be an act manifesting an intention or threat to commit battery, and also the person giving that or manifesting that intention or threat to commit battery has the capacity or ability to carry out that intention. Again, we moved ahead to appreciate 3 cases in looking at or taking or running through these 2 elements. We considered the case of Reed versus Coker, where the court said that assault will lie because the defendant and his workmen had that ability or capability to carry out the intention of telling the plaintiff that if he does not leave their premise, they are going to break his neck. In the case of Stephen versus Myers, the court as well stated that assault will lie in that particular instance because with regards to assault, with regards to that case, the gentleman coming out or the defendant coming out with a fist and moving towards the chairman had that capacity to carry out the intention of committing battery on the chairman, but for being prevented by some of the members in the meeting. We consider the case of Thomas versus National Union of Mine Workers, where the court stated that in that particular instance, assault will not lie. Reason being that though the National Union of Mine Workers were threatening violence, they did not have the capacity to carry out that violence because Thomas and his other colleagues were in a moving vehicle and also had security officer in it to protect them. Not even only that, the National Union of Mine Workers did not also touch their car or do anything to them to show an ability or capability to carry out their intention. Now we moved ahead to appreciate the gun cases. In the gun cases, the challenges on the revolver, where we stated that the court has moved from the position of law in Blake and Barnard, moved to Osborne and Veitch, and now the current position of the law is in R versus St. George, where we stated that when I point a revolver at you, whether or not it is loaded, assault will lie until I am able to establish to the court that you had knowledge that the revolver did not or was not loaded. We moved ahead to appreciate whether mere words would constitute assault, where we consider the case of R and Mead and Belt or versus Mead and Belt, and the court stated that in that particular instance, assault will not lie because the gentleman shouting at night behind the plaintiffs or the defendants building did not have the capacity to carry out the said intention. However, in R versus Wilson, the court stated that the gentleman shouting, "Get me the knife," while the gentleman or the victim was moving out of the game house or the game shop, the court stated that in that particular instance, assault will lie. Also, in the case of R versus Constanza, writing over 800 letters, which led to the lady suffering from psychological problems, the court stated that in that particular instance, assault will lie. We looked at conditional statement, and we stated that with conditional statement, assault will not lie because the condition negates the capacity of the person to carry out the said battery or the intention of committing battery. And we looked at the case of Tuberville versus Salvage. I call it the Assise case, where the defendant touched his sword and said that if not Assise, you would have seen what I would have done to you. Now, we looked at assessment of damages, where we stated that with regards to assessment of damages, both assault and battery are actionable per se. Where actionable per se, we meant that you need not to prove any actual injury. However, when there is an actual injury, it increases the quantum of damages. Ladies and gentlemen, thank you so much for being with me. I would appreciate your kind and sincere feedback in the comment section. This is the Law Lab, and until we meet again, I say thank you. Remember, I've always been saying, do not take all your matters to God. Take some to your lawyer. Thank you very much.